I've spoken before about the question of whether environmental protesters at sea could be considered pirates if they resort to violence. Now I'm going to come back to the question of the definition of piracy and what it does and doesn't cover in more detail. And I want to look at that in historical context and show how the same words aren't always given the same meaning when we look at the international law of piracy. So I want to do this in several steps. I want to talk about the problem of the international law category of pirates and how it relates to legal concepts of war and politics. I want to talk about codification efforts between 1926 and 1982. I'm going to touch briefly on modern case law in its context, and then finally the question of whether we see in contemporary responses to Somali piracy a return to the laws of war paradigm. And the short answer there is no, just to give the game away. But let's start then with this first question, the difficult category of pirates. The first point I want to make is that the modern legal definition of piracy is the result of 20th century codification efforts, and what the codifiers were attempting to do was resolve difficult and chaotic material, and particularly the distinction between the laws of piracy and the laws of war. And we'll come to those points in more detail shortly. But throughout this presentation, bear in mind that there are several different ways we can think of pirates as a legal concept. So the first is the vision of the pirate as a robber. So the pirate is motivated by financial gain, and the crime of piracy is essentially one of theft. The other possibility is the pirate contrasted with the state-licensed privateer, or the insurgent, so a civil war combatant who is engaged in what we would now call a non-international armed conflict, attempting to overthrow a government. So these are categories of either state sanction or the laws of war. So the pirate is contrasted with, as it were, legitimate authority or at least lawful forms of warfare. And the third possibility is the pirate as someone without politics. So they have no legitimate connection to a state polity or have no status under the laws of war or have no political objectives in a broader sense. So these are the different ways we can think about pirate, and they crop up in all of the definitions. So here's the modern definition as we find it in treaty law. Piracy consists of any illegal acts of violence or detention or depredation committed for private ends by the crew or passengers of a private ship and directed on the high seas against another ship or persons or property on board. And the words I want to focus on are those three words, for private ends. So private ends, if we think of our three categories again, could mean that you are motivated by gain, so you're a robber. You're not motivated by politics, so the contrast is between private and the political, or your acts are not sanctioned by a state or the laws of war. So here the contrast would be between private ends and public or lawful powers. And one of the difficulties we face is that codifiers have not always been clear which of these concepts they're talking about. So the words for private ends can also be thought of in another two ways. Lawyers like dichotomies, and one of them is the difference between subjective and objective tests. So one possibility is that the word for private ends creates a subjective test of motivation. Do you have private motives or do you have political motives? And this idea goes back to at least Ambassador Matsuda at the League of Nations in 1926, although he favoured other approaches as well, as we'll soon see. Or we can give the words for private ends an objective test. That is, we're contrasting private violence and state sanction. And that view of what for private ends means has a long history going back probably into Renaissance thinking and the works of Gentili, but is also found in the works of Herschel Lauterpacht in the 20th century. But here's a deeper question that troubled me when I was thinking about this issue. Where do the words for private ends actually come from? So we certainly find them in the modern 20th century treaty law in both the High Seas Convention of 1958 and the UN Convention on the Law of the Sea. And both of those treaties took the wording from the International Law Commission, the United Nations body of legal experts, Draft Articles on the Law of the Sea of 1956. The International Law Commission, in fact, drew them from the Harvard Research in International Law in 1932 and its Draft Convention on Piracy. But where did the Harvard Research team get them from? Actually, it drew the words from the League of Nations Draft Articles on Piracy by Ambassador Matsuda, produced in 1926. Now, this was a very brief document. Matsuda did not give us footnotes, he did not give us a bibliography. He gave us only a sketch of an explanatory memorandum for his articles. But it looks as though both he and the Harvard drafters probably drew these words from Joel Prentice Bishop and his book New Commentaries on the Criminal Law, the 9th edition of 1892. Now, Bishop was extremely influential as a criminal lawyer in the late 19th century. He was a self-taught American. His books were widely read and translated. He was awarded honorary doctorates by foreign universities, and he was certainly quoted both by the Harvard codifiers and indeed by some of the foreign sources that they relied upon. So the German jurist Style quoted Bishop quite often. So it seems very likely. Also, this is the first reference in any book anywhere that uses the words for private ends in relation to piracy that I have been able to find. So it looks very likely that Matsuda picked the words up from Bishop, and certainly the Harvard drafters did. But where did Bishop draw them from? Well, he's a scholar. Wouldn't we expect him to have pulled these out of old cases for private ends? You know, we're talking about piracy. Doesn't this come from a rich common history case law? Well, the answer is, as far as I can work out, no. And if we look to U.S. and Smith, the 1821 case, Justice Story has one of the most wonderful things in legal history, an extraordinary 18-page footnote in which he compiles every English, French, and Latin definition of piracy that he can find. And not one of those definitions contains the word for private ends or anything that could be translated into the words for private ends. So there is no case law before 1892. So what are we left with? Well, we're left with Bishop, and when Bishop used these words, he was using them as a synonym for intent to rob. He was thinking only of piracy as robbery when he used those words. All right, so the difficulty with that piracy as robbery conception, though, was this confused case law I already spoke about. So things that were tried as piracy were never limited to cases of just robbery. So, for example, in 1934, the UK Privy Council says in Re Piracy Jure Gentium, piracy includes any armed violence at sea which is not a lawful act of war. And similarly, the US Supreme Court in the Ambrose Light in the late 19th century describes piracy as unauthorized warfare. So robbery was always too narrow a category, and you had to work out what to do with these broader concepts of piracy. And that's where we get to the codification effort. So if piracy is not political, well, what's this political other that the codifiers, what are they trying to exclude by use of the word private here? So the key question for them, the difficult case, was Civil War insurgents. Freedom fighters, revolutionaries, armed bands, call them what you will, who took up arms against a government and also took to the seas. So there was some case law suggesting that such insurgents in the 19th century could be assimilated to pirates, particularly if they attacked foreign shipping. Now, in a war, you might want to do that. You might want to blockade the enemy's ports. You might want to enforce contraband. You may wish to stop supplies getting to the enemy. But if you're not a government and you do that to the ships of another state flying a foreign flag, are you a pirate? So this was actually a question of the laws of naval warfare in times of civil war. And in the 19th century, that question was resolved by the doctrine of recognition of belligerency. That is, if a foreign government recognizes that you are a belligerent, you go from being an armed band with no status to a combatant in a war. You may also be given this status by the very government you're trying to overthrow, if they recognize that in effect you are acting as an organized armed group that they are engaged in conflict with. But there were tricky questions about the extent to which recognized insurgents had rights opposable to neutrals, to powers that weren't part of the conflict. Could they only stop and search the shipping of states that had recognized them, or did they have broader objective powers? And outside of those conditions, were they pirates? So this is the hard case. And it's first dealt with by the League of Nations Committee of Experts for the Progressive Codification of International Law, and as I've mentioned, Ambassador Matsuda. So Matsuda's draft articles on piracy commence with this: piracy occurs only on the high seas and consists of the commission for private ends of depredations upon property or acts of violence against persons. So nice, objective, acts-focused definition. It is not required that such acts should be committed for the purpose of gain, because as we've already said, it was acknowledged that robbery was too narrow a category. But acts committed with a purely political object will not be regarded as constituting piracy. So there's some exception here in the Matsuda draft. The question is what that means. Well, Matsuda himself goes on to say that piracy consists in sailing the seas for private ends without authorization from any state. So he does seem to favour this state sanction theory. And he goes on to say it is better to be content with the external character of the facts without entering too far into the often delicate question of motives. So on the Matsuda view, you commit unlawful, non-state sanctioned violence at sea, you're a pirate. We don't ask about your motives. Except, he goes on to say, nevertheless, when the acts in question are committed from purely political motives, it is hardly possible to regard them as piracy. So he has a general rule, then he has this exception. But what does he mean by political motives? Well, let's bring this into the context of the debate about Civil War insurgents. So his Article 4 provides insurgents committing acts of the kind mentioned in Article 1 must be considered as pirates unless such acts are inspired by purely political motives. Alright, so we still have this exception, but note, his starting point is insurgents can be pirates. So he seems to be backing this state sanction theory. And the League of Nations Committee President said, summing up the debate they had on these articles, in the general case, whether the crime of piracy has been committed follows from the character of the acts. If the acts of violence or depredation are committed, there is piracy, regardless of motives. Nevertheless, the rapporteur has admitted an exception for acts committed for a purpose which is political and solely political. So, general position, motives don't count. Then we have this question. The question is, despite the fact that the law on piracy can extend to by analogy to insurgents who attack foreign shipping, there's this exception, a narrow exception for purely political acts. What does it mean? Well, we don't know, because the League of Nations didn't tell us and they abandoned the whole project as impractical. So the next researchers to take the issue up was the Harvard research in 1932, actually largely conducted out of Stanford University and by Californian academics. So it struggled with a number of hard cases where case law had treated as pirates attacks for some political purpose not made under the authority of any state or recognized belligerent government, attacks on commerce by privateers, and participation in privateering attacks of a foreign belligerent on commerce of a nation with which the offender's state of nationality is at peace. These were the difficult cases. Were they part of the law of piracy or not? So what the Harvard draft did was use the words for private ends to distinguish between acts by states, recognized belligerent organizations, or unrecognized revolutionary bands. Those acts were not to be piracy. And the difficult case of Civil War insurgents, unrecognized revolutionary bands, well, they said illegal acts of war by unrecognised belligerents constitute a special offence. Not piracy, but something else, some separate offence that can be punished by an offended state. So revolutionaries attack your shipping, you have protective rights to prosecute those revolutionaries, but that doesn't make them pirates, is the Harvard draft view. So here's the difficulty. The words for private ends are used to mean or signal very different things. For the League of Nations in 1926, the words for private ends meant that unlawful belligerent acts can be piracy. Those acts can be subject to universal jurisdiction and prosecution by any state, but there's a narrow exception for purely political motives. The Harvard research in 1932 uses the same words to mean that unlawful belligerent acts are not piracy, and they're covered by a separate rule, and jurisdiction vests only in the offended state. There isn't universal jurisdiction given to every court in the world. So despite this lack of historical consensus as to the meaning and purpose of these words, the words for private ends are adopted by the International Law Commission in 1956 and the treaty law that follows. Alright, so that's how we've wound up with the words. What do they mean? Has modern case law helped sort this out? Well, we'd expect that modern case law would be driven by Somali piracy and the large number of Somali pirate attacks there have been in recent years, although happily that number is now declining very significantly. And certainly there has been an increase in case law on piracy following Somali piracy and prosecutions in Kenya, the Seychelles, France, Germany, the Netherlands, the US, and many other jurisdictions. But the interesting point to note is that generally private ends has not been an issue in the trial of Somali pirates. It hasn't come up. These guys are hijackers and ransom seekers. They're acting for gain. They have not agitated the question of private ends in their defence. But what about environmental protest? Will these be the cases that tell us whether the test is lack of state sanction, an objective test, or is it a question of your private internal motives? So in a 1986 Belgian case, Castle John, a Belgian court held that a Greenpeace vessel had committed piracy by attacking an allegedly polluting Dutch vessel. And the court said in that case the violence was conducted in support of a personal point of view. Academics didn't like this case, and it was generally suggested in textbooks that other courts wouldn't follow this approach. But we then get to Institute of Cetacean Research and Sea Shepherd Conservation Society of this year, which dealt with violent acts without state sanction and held such acts at sea when committed against another vessel to be piracy. Chief Justice Kaczynski said, "You don't need a peg leg or an eye patch when you ram ships, hurl glass containers of acid, drag metal-reinforced ropes in the water to damage propellers and rudders, launch smoke bombs and flares with hooks, and point high-powered lasers at other ships. You are without a doubt a pirate, no matter how high-minded you believe your purpose to be." This is violence against shipping. That's the critical test. And Chief Justice Kaczynski said further, "We give words their ordinary meaning unless the context requires otherwise. The context here is provided by the rich history of piracy law, which defines acts taken for private ends as those not taken on behalf of a state." And there we have the US federal court approach, at least at present, to what the words for private ends mean. Okay, however, that leaves me finally to speak about, well, what's happening in relation to Somali piracy? There are a lot of navies out there patrolling against Somali pirates. Does that mean we're returning to a law of war paradigm when we have actors like the EU naval force out there countering piracy? Well, the simple answer is no. There has been no serious calls to assimilate Somali piracy to the war on terror or to invoke the laws of war, beyond certain US largely academic commentary. The Security Council, the EU naval force, NATO, the various other missions involved have all been very clear that Somali counter-piracy is a law enforcement operation. It does not operate under the law of armed conflict or the law of war. So my final thoughts are these. We are not presently at war with pirates, though war has shaped the historical definition. The words for private ends can simply mean unauthorized violence, and modern case law seems to be trending that way, although the driving cases at the moment are environmental protest, the Sea Shepherd case before the US courts, and the older Castle John case before Belgian courts, not Somali piracy cases. And it will be interesting to see how further environmental protest cases are dealt with, and whether the Sea Shepherd case in particular proves influential or not.